The Sarasota County Bar Association is a proud partner in bringing you Law in Sarasota. With voluntary membership of over 900 lawyers and judges, the Sarasota County Bar Association is your community's leader in advancing legal professionalism, practice development, and public service. Visit www.sarasotabar.com for more information and to use the online directory list to find an attorney.
Welcome to Law in Sarasota. I'm Senior Judge Lee Hayworth. This program is brought to you by a grant from the Community Foundation of Sarasota County and the Sarasota County Bar Association. The Education Channel produces the program and broadcasts from its state-of-the-art campus on Beneva Road. They make this program possible. Circuit judges serving in the family division often face parents fighting over their kids. These high-conflict cases are life-changing for the children, and they're especially vexing for judges. Judges are called upon to decide how much time, if any, each parent is to have with his or her child. In the process, parents will often report the most shocking claims about the unfitness of the other parent. These may be true, or they may not be. How to determine the truth? When a judge is presented with conflicting accusations, the only evidence he or she has to make the decision traditionally comes exclusively from the litigants or biased witnesses. Some parents have lawyers, most statistically do not. They have no attorney and are self-represented, what we call pro se. This poses particular challenges for judges who are trying to determine, above all, what is in the best interest of the children. In 2014, the 12th Judicial Circuit adopted a new program, one that is made possible only with the volunteer services of local lawyers, members of the Sarasota County Bar Association. It is known as the Family Division Guardian Ad Litem Program. Local attorneys are recruited and trained to act as the eyes and ears of the court, to meet with the children, the parents, collateral sources such as family members, teachers, and doctors, and to report back to the judge with their recommendations on time sharing and parenting plans. Now, this is authorized by statute, and it requires discretion, objectivity, and a high level of ethical conduct. Now, the parents remain free to disagree with any of the guardian ad litem's recommendations, as does the judge. But this provides an independent source of information about the family dynamics. This resource can lead to a more positive, child-focused judicial decision. Now, we have on our panel today two veterans of Family Division Guardian Ad Litem Program, and I've asked them to come today to share their experiences. First, we have Judge Stephen Walker. Next to Steve is Attorney Robert Young. Welcome, folks.
Thank you for having us.
Yes, thank you.
Now, Judge Walker rotated out of the family division after 2 years as a family.
3 years, actually.
3 years? And he moved into the criminal division, but he still maintains an interest in what's going on with the Guardian Ad Litem program, for which we're fortunate. Now, Robert Young is an attorney with Brand Gates Dramis, and he was formerly with Eichard Merrill. He received his undergraduate degree from the University of Miami, and then he went to the University of Illinois, got his JD on a scholarship. I also need to say that Mr. Young is the recipient and probably the youngest we've ever had to receive the Sarasota County Bar Association's Pro Bono Service Award, which means he devoted a lot of time to helping people who could not afford a lawyer. So we're going to start with you, Judge Walker. So tell us about the Guardian Ad program, well, what it was like before you had the Guardian Ad Litem program.
Well, first of all, I met with you before I took the bench in January of 2015, and you did your best to explain to me the value of this program. But it did take some time presiding in the Family Law Division for me to see the value of the program and see where people, dedicated volunteers, could serve in this role and essentially mine some very, very important data for me, vital, invaluable data and information to allow me to meet my obligation, which is to make a decision, an informed decision on the best interest of the children. What you touched on in your in your opening is very true. Oftentimes, the information that is presented to the court in the proceedings is from people who you have to be compassionate and understand what they're going through, but it can be so emotional and it can be distorted, and there can be, in cases where there's high conflict, there can be some very disturbing allegations made. Where I have seen this program, volunteers like Mr. Young, when I appoint them to get involved in this, everything is done by order. The role of the family division guardian ad litem is very well defined, and they're able to go protect the children from the courtroom, meaning that children will not be brought in, and yet we're validating their interests, their concerns. They understand that they are part of the procedure, and I'm able to get information with regard to school records, how the conflict in the home is impacting them. The information that comes to me puts me in a situation where I may be able to put the family or connect the family with really valuable resources to benefit the children.
Well, are most of these cases that you deal with, are there lawyers asking for this, or do you pick the cases? And how do you handle the pro ses, the unrepresented?
When I have unrepresented cases with pro ses, oftentimes I or my colleagues could get a feel for the level of conflict by the pleadings. When you start to see emergency motions being filed or accusations that are made from one parent to another, it's time to get the parties in front of you for a case management, to try to get an evaluation as to where things are and where things are going. When I have pro ses and I could identify conflict, I was very proactive because of the things that you taught me about discussing this program with people. I felt that if I had pro se litigants and I could take the time to explain the program, explain that they were going to be part of this, and talk to them about my obligation for the children. When there was resistance, and oftentimes there'd be a party that would say, well, I'm worried because the other party is going to influence the children to say a certain thing, or they're engaged in alienation. I would try to explain that the guardian is, you're going to be able to make the guardian aware of that, identify those issues. They'll go in with their eyes open to those things. When I felt it was something to not just come in and impose on the parties, but seek their feedback and try to explain to them the benefit and how. By doing this, I'm going to be able to make a much more informed decision, because information that a guardian might be able to get and include in the report and bring to me with the consent of the parties might be information that otherwise I wouldn't get.
Well, this is an area where parents tend to be paranoid about somebody coming into their family relationship and reporting back to a judge. How do you handle that when you're speaking to a litigant who is very obviously oppositional to the whole concept?
I acknowledge it and recognize that it's understandable that someone that they don't know is going to come in and get information, and it's okay to be nervous about that. My experience, however, was, and I had taken over some cases where there were family division guardians appointed, and I saw the end result before I saw the beginning or the genesis of the cases. And what I was able to explain to people is, in almost every circumstance, the parents welcomed the ultimate input. There might have been resistance at the outset, but ultimately the information was so valuable. And again, they're part of the process. They're getting information to the guardian. They're working with the person. And each case depends on the right guardian for the case. And even in instances where I saw opposition and high conflict at the genesis of the process, I was fortunate enough to see people who would take the time and interrupt the proceedings to thank the guardian for the work that they've done. I've had situations where the parents both hugged the guardian because they so appreciated the invaluable work that they've done. When I speak to parties and I acknowledge what they're going through, the fear, the unknown, the fact that there's now a seismic change in their life, there are financial dynamics, there are emotional dynamics. The most important thing in their world is the decision that ultimately someone like me is going to make.
So how is the actual, well, let's start, how does the ball get rolling? You mentioned an order. What sort of things are in the order that you signed to get this thing moving?
The order, which was drafted by a judge that was much smarter than me, and I think you're familiar with the genesis of the order, it's very dense as far as what it covers. There's the authorization to the guardian is to have access to records, to have access to individuals, to be able to conduct a factual investigation into the allegations that are set forth in the pleadings. With this order, they can go to a school and have access to school records. In some instances, they're going to be able to get medical records. They're going to have an opportunity to speak with collateral sources to gain information. And if there is resistance from any entity, the guardian ad litem has the power to set a hearing, to let the court know, to have a case management to address any of those issues. Also, when we're talking about crafting the specifics of the order, we have the general template. The parties are there, and on pro se cases where there is no lawyer, I'm explaining to them the different provisions, why these provisions are important, and the benefit that it's going to have to me and to them. And also, they reserve the right to voice objections, to present other evidence to explain why maybe something in the report is not factually accurate, or that there's information to supplement that. So the most important provision, I think, has to do with paragraph number 11 in the standard order, and that deals with the inclusion of child hearsay. And that is the mechanism by which the guardian ad litem can actually report back to the court the statements, the input of the children.
And also the other people that report in, right?
Absolutely, absolutely.
And so it saves time at trial, because they don't have to call these witnesses in to repeat the same information.
It saves time at trial, and it saves enormous financial resources for parties that may not be able to get that information. But from a judicial standpoint, it saves the child the trauma of having to come into the courtroom. But at the same time, we're recognizing that their input is valuable to the court.
And let me say, any of our viewers that want to know more about what this order says and what the provisions are can go to the 12th Judicial Circuit website, and there we published this order. There's also a Supreme Court order, which we've taken and modified it uniquely for our circuit, but it would explain a lot of the things that Judge Walker has just talked about. Let's turn now to somebody who's been in the trenches, probably literally, with some of these cases, and we'll turn to Robert Young. And so, Robert, tell me, let's talk first about your training that you got as a guardian ad litem. What sort of things did you have to learn about to be a guardian ad litem?
Well, I would start by saying that everyone who is in the guardian ad litem program for the family division are attorneys. And so everyone's gone to law school, passed the bar, and they've practiced for at least a year or two before they're asked to become a guardian like I was.
And there's a statute that says members of the bar can serve as guardians.
Absolutely. And so the training that we receive, I would say, is to teach lawyers how not to think like lawyers when they become guardians, because your job is no longer to advocate for a specific side or party, or even for the children. If you're an advocate for the children, when a child who's 13 years old says, I don't want to live with my dad anymore, your job as an advocate is to go and tell the judge that the child shouldn't be living with their father, and this is why. But as a guardian, you don't do that. You're acting beyond.
So the first rule is you're not their lawyer.
That's right.
Okay. And how about things about, let's talk about confidentiality. How do you, did you learn about the confidentiality requirements, and basically what are they?
Sure. So it's kind of a two-sided thing, because everything that a guardian does in a case is confidential In fact, the local clerk of court has done a great job of sealing the records so that anything that's put into a report and given to the judge, or rather even filed with the clerk, nobody can view it, not even the guardian who files it, unless they specifically request permission from the clerk, and then the clerk looks at it and unseals it for them alone. So there's a lot of confidentiality on that side. However, once again, like as an attorney, usually when you are speaking to someone one-on-one, you're doing so in confidence because your conversations are not supposed to be broadcast to the other side or to the judge or anything like that. But as a guardian, it's in fact the exact opposite. All of the conversations that you have with both parents, with the children, with third parties, you can bring before the judge if you believe that it is relevant and it's important for the judge to know in order to make a decision. So on one hand, there's a lot of confidentiality, but on the other, there's none.
So part of your responsibility is to prepare a report, and I assume both parents get a copy.
Yes.
And then the judge can receive this and review that and have a hearing, and do you have to go to testify?
Most of the time. So well, I'll take a step back and say that what has happened the most when I submit a report is that the parties decide to mediate the issues again instead of going in front of the judge. Perhaps because in most cases there's not a right side or a wrong side. Both parties have some things that they got right, some things they got wrong, and when I lay it all out, they typically say, okay, I don't want the judge to see all the bad things I did, but maybe we can focus on the good things and work from there. But in the event that the report does go in front of a judge, I almost always have to be present to testify about my report because I basically have to explain things or verify certain information that's in there.
Well, now the interesting thing about this is that the order that the judge signs has a suggested cap on the number of hours you would expend pro bono. Were you able to stay within that, Robert?
I think there might have been one case that I was able to stay within.
What's the most you spent on one case?
Oh, we had actually, Judge Walker and I were involved in a case that I don't think either of us are involved in anymore. I think it was 300 hours at one point.
For goodness sakes. Yeah. One of the...
May I say something?
Yeah,
with
go
regard
right
to that?
ahead, sure.
We all have heard people make lawyer jokes, talk about our profession in a way that can be disparaging, and that's accepted in many circles.
Sometimes it's funny.
It's not something that I will allow without commenting on the Family Division Guardian Ad Litem program, because the lawyers that work in this program, the amount of time that they give, their dedication to the children, I know because I've been told that these are the cases that keep them up at night. I've not seen anyone stay within the required hours where they are signing up for a certain amount of hours that they're going to give to this case. I've never seen a Family Division Guardian Ad Litem not exceed that. And they do it because they care so much about these kids.
And the nice thing about this service that they're providing, it benefits Legal Aid of Minnesota, which is the official pro bono provider of services here in our county, in the circuit. And they get credit when he spends 200 or 300 hours on a case. That helps them show the contributions that lawyers are making in the community. So let me go back and ask, Judge Walker mentioned collaterals. So give examples of the sort of people other than parents that you would interact with in order to get information about how these children are really doing.
Sure. I will say that I always start with the parents, and they are the best sources of lists of collaterals. Well, you should talk to my aunt this or my uncle or their cousins or whoever. And so they always give a list of people that probably favor one side or the other. But they are good sources because it's surprising how often those collaterals do not line up their stories with what the parents are saying is going on. Not that one side is lying, but again, they're a little further removed from the emotions, and they can better see their side of things. But I always start with teachers. I mean, you're dealing with children. All children are in school, and oftentimes the children spend more time with their teachers in a given week than they do with either parent, particularly if the parents already have a shared time-sharing schedule where it's 50% with mom, 50% with dad. That means the teachers who see them 5 out of 7 days see them the most. So they oftentimes, even if the teachers simply say that that there's nothing going on, that they're a great student, that's also good information to have, even if there's nothing of note, because we know behind the scenes that there is a lot of stuff of note going on between their parents and at home, and so if the child isn't exhibiting that at school, that's a good sign.
How about medical providers? Can you access information concerning their health?
Yes, if it's raised in the particular case, I have spoken to doctors, pediatricians, some counselors, some psychologists, and it depends on the medical provider. Some are very open about their relationship with the families, both parents, the children, and of course they produce their documents that they have. Some are a little more hesitant because they only work through one parent, and they're worried about losing the trust of the child when the child wants to tell them things. So it can vary, but yeah, they're all very welcoming.
So every attorney who qualifies as a guardian has to go through a training session where they're presented information concerning the statutes that affect guardians ad litem. And by the way, we should, ad litem obviously is a Latin phrase, but we think of guardians ad litem as the next friend of the child. And that's basically a rough translation of that, I suppose. And let's talk about the immunity from liability. What if you do something that they don't like? Can you get sued?
Well, I mean, somebody can try to, but apparently there's a lot of very strong immunity built into the statute.
They have to show bad faith, I think, which is going to be very difficult.
And I think the number one thing that I do at the beginning is to listen to what both parties have to say, because oftentimes, especially with pro se litigants, they don't feel like they truly get to tell their side of the story, and the guardian is a perfect vehicle for them to at least tell someone who is involved in the case and can bring that before the judge. And I usually tell them that the whole story won't be set in front of the judge, but it wouldn't be anyway, even if there wasn't a guardian.
Right.
So
That's a very important point, because with pro se litigants, when you're dealing about issues with children, if they don't have a fundamental understanding of legal procedure, they all have a story to tell. And in court, you are going to, by nature of the proceedings, be drastically limited. The opportunity to sit down with someone who is there to investigate the best interest of the child or the children or the 4 children under the age of 12 that are in this household, to be able to tell that story is very empowering, and it helps the parents to buy into this process. And Mr. Young also commented on something that I think is really important. Adversarial litigation is bad for children. When there's a report that can be done by someone like Mr. Young, where at the conclusion of it, the parties are reading something and now they're talking about resolution from a different standpoint, and they're going back into a mediation, adopting a different position based on this report, it saves time, it helps lessen the conflict, and that is invaluable.
The goal is to develop a time-sharing plan and also a parenting plan. Let's talk a little bit about what is a time-sharing plan. What about a parent who is so disturbed or dangerous to the children that you really can't allow that? How would that be treated by a guardian ad litem or by a judge?
Well, first of all, a judge has wide discretion. If there are circumstances where a parent's time sharing has to be drastically limited, or if they have to have only supervised time sharing, then there needs to be steps put in place or benchmarks where if the parent is able to meet certain goals, they can reestablish or expand on the restrictions of time sharing. Sometimes that can be too daunting. Sometimes the individual might be so struggling with chemical dependency or some type of emotional issues that it's never going to be anything other than maybe through the Supervised Visitation Center in South County, where we know that the visitation is going to be safe, it's going to be monitored, there's not going to be any inappropriate behavior. We have a wide authority, and we have different plans that we can put in place. And there are myriad options that we can formulate. I always seek input, and I think all judges do, from the parties as far as a structure, but ultimately it comes down to the judge to define specifically when throughout the week the parents will have time sharing with the children.
So it could be 50-50, it could be 70-30, it could be 80-20 during a week or a month. Is that
Yes,
how it works?
yes.
And then you have the parenting plans where you have to work out all sorts of details about where the kids go to school, how they agree upon that, and medical treatment, all those sort of issues. I'm sure you've done plenty of the parenting plans, and they're very tedious, I think.
I think it really helps that as a family law practitioner, I'm able to understand the parenting plans more. I've worked as an attorney on cases where guardians have been appointed, and sometimes they'll shy away from getting into the details because they're not family law practitioners. But yeah, I think that's very, very helpful just to lay it out because, again, the parties oftentimes work it out on their own.
I'd like to thank our guests for sharing their experiences. This Guardian Ad Litem initiative is a significant innovation. It improves judicial decision-making in an area of vital importance to children and their parents. It exists because local attorneys take time away from their practice and making a living to volunteer free time on behalf of children. It's yet another example of how Sarasota lawyers engage in selfless projects to benefit the community. If our viewers are engaged in a family law litigation where children are caught in the middle of a bitter custody dispute, or if they know of others facing such situations, their attorneys and the parents should know about this program, and they can ask the judge if he or she is willing to consider appointing a guardian. We thank you for watching.
For more than 36 years, the Community Foundation of Sarasota County has worked one-on-one with estate planning attorneys and their clients to make a lasting impact through philanthropy. Stable, trusted, and knowledgeable, the Community Foundation safeguards the charitable legacies of donors to ensure that they continue for years to come. Visit www.cfsarasota.org or call 955-3000 for more information.